The chair is authorized to declare a recess at any time. Today, we welcome everyone here for this hearing on intellectual property and strategic competition with China. Before I recognize myself, I want to thank everyone for being here for what is clearly an investment hearing. I'll now officially recognize myself, probably for the same statement by my staff. Good morning. I'd welcome everyone to the hearing today. This hearing marks the fourth in a series of hearings focused on strategic competition with China. As this committee has documented, the People's Republic of China has been leveraging their international IP system to serve their strategic interest. Our first hearing on the topic delivered China's recognition of China's intellectual property theft and the rise of national champions such as Huawei and ZTE. We looked at China's emergence as the largest filer of international patents and subsequent use of U.S. patent in litigations against American companies, all with significant national security concerns. The second hearing examined how actions under the Biden administration allowed greater foreign access to U.S. advanced technology by waiving IP protections under the TRIPS waiver provision. This failure threatened to harm U.S. innovation and jeopardize investments in life-saving medical advancements. The third hearing analyzed the artificial intelligence arms race between the U.S. and China. We explored how Chinese AI development threatens a wide range of industries, including our own cybersecurity. Today, we will address China's Standard 2035 strategy, a sophisticated and dangerous plan aimed at dominating critical global technologies by shaping international standards. This hearing will explore the PRC's manipulation of global standard-setting organizations through overwhelming and coordinated participation in state-backed entities. And I want to emphasize, it is their leaning into organizations that often the U.S. does not fully staff to the level we could, and in fact are often requested to. And that leaves a void, and China has happily not only filled the void, but lobbied for more slots. China's unified effort to stack the deck at SSOs allows them to dominate the discussion and embed PRC technology into global standards such as 5G, AI, and the Internet of Things. In particular, we will investigate how the PRC exploits licensing and rate-setting mechanisms for standard essential patents in favor of Chinese companies. This behavior includes leveraging Chinese courts lacking independence or impartiality to set global licensing terms and undermine foreign competitors, particularly those in the United States. And it includes suing competitors in the United States, in the European Union, by leveraging patents essential to important technology standards like 5G and others. Finally, this hearing will highlight the broader implications of the PRC's effort, including the erosion of U.S. technological leadership and the entrenchment of the PRC's dominant technologies into global infrastructure. Let us be clear, this committee is not the committee that will keep us from losing our lead. This is simply the canary in the coal mines. We cannot let the PRC dominate global standards, and yet, as we speak, they have made significant advancements in the previous 8 years, 6 years, 4 years, 2 years, and as we speak. I want to thank our witnesses for their time today, and as I said before the opening, this as the last hearing of this Congress is but a down payment on what we must do in the next Congress. now my pleasure to recognize the ranking member, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman. You know, when we, each of us has a cell phone, more than likely, and many of us look at that cell phone as just one single entity unto itself. And it's amazing that this same phone is held up by people across the world. And looking at the coverage on Syria last week, you see folks, you know, holding up their phones, recording the moment. And, you know, these phones and other products, we can't see inside, but there is not just one patent or one product in these phones or in many devices. It's made up of over 1,000 patents, this phone. Some are owned by the cell phone manufacturer, some are licensed from the owner, and a few are known as standard essential patents, or SEPs. These patents are designated SEPs by standards-setting organizations, meaning that they are necessary to make a cell phone work to global standards. The phones in our pockets are the very same as those in the pockets of people across the world, because it's the same on the inside, because they need to be interoperable so that people in Syria and China and wherever else they are can use them. I can call someone in Iran, I guess, and maybe get them on the phone, same phone we're using.
Chinese will listen as you call.
And that's true. Standard essential patents guarantee worldwide interoperability of our technology. By requiring a universal set of patents for a device, global standards ensure that as technology advances, our machines are interoperable with the world around them, and that's a good thing. These standards hinge on inventors being fairly compensated for their inventions, so long as they agree to license their products on fair, reasonable, and non-discriminatory terms, known in the trade as FRAND. We are here today to examine the question of what happens when a country refuses to abide by the international process to which every other country adheres. Over the last decade, Chinese courts have advanced its government's technology dominance goals through legal decisions that put China out of step with the rest of the world. Courts in China have set royalty rates artificially low for U.S. companies. They've ruled in favor of anti-suit injunctions that prevent litigants from bringing patent suits in other countries' courts, and otherwise prevented SEP owners from being paid fairly for their inventions. Transparency in litigation is another problem. Chinese court proceedings are infrequently published, making it difficult for litigants, international courts, and SEP owners to interpret rulings or to have any semblance of a rule of law. This absence of clarity has created a complicated system where the deck is stacked against American companies, one that is hard to navigate and where litigants struggle to receive a fair trial. I'm looking forward to hearing from our witnesses on how we should approach this problem. We cannot expect, much less demand, that the United States always come out ahead. Similarly, it would be unwise to lower ourselves to the lowest common denominator, making our system similarly unfair to litigants who use systems other than the United States, or making the system unfair to patent holders will not even the score. Imitating China will not make the U.S. more American. It will take a worldwide effort to overcome China's overreach on SEPs. International institutions like the World Trade Organization should seriously consider whether nations are meeting their obligations under the TRIPS agreement. We should be able to turn to international forums for fair adjudication of disputes, including the use of anti-suit injunctions by Chinese courts. By working cooperatively through diplomacy and dialogue, Nations disadvantaged by China's unfair decisions can demand a system that provides transparency and due process at a global level. But America also has an obligation to lead the way. We should invest in making our patent courts faster, make sure we get more judges on the bench who are steeped in patent law, and attract litigation by having a better process in America for adjudicating disputes. Other countries will not follow the U.S. blindly. We need to prove we have a better process to incentivize litigation here at home. I thank my colleagues across the aisle. Chairman Issa, I thank you for holding this hearing and working with me on a bipartisan basis over the last 2 years on all that we have worked on together. I thank Ranking Member Nadler for his support and for his friendship, and I thank the witnesses for being here today. And with that, I yield back the balance of my time, but not before wishing everyone a happy holiday.
Without objection, all other opening statements will be included in the record. My pleasure to introduce our witnesses. First, we have Professor Thomas Cotter. Mr. Cotter is a professor of law at the University of Minnesota Law School. His research focuses on domestic and international intellectual property law, antitrust law, and economics. He is the author of 7 books, including several on intellectual property law. Next, we have Mr. Kent Baker. Mr. Baker is head of IP strategy, litigation, and licensing of intellectual property and standards for u-blox America, which provides wireless semiconductor chips, modules, and other technological components. He is a patent attorney by trade and has more than 30 years of experience in engineering and practice of law and academia on topics of intellectual property, standards, policy, and regulatory policy, and welcome. Mr. Mark Cohen. Mr. Cohen is a senior fellow at George Mason University, Antonin Scalia School of Law, and a senior technology fellow at the Asia Society of Northern California. He previously served as senior counsel to the Patent and Trademark Office. Dr. Walter Copan is the vice president for research and technology transfer at the Colorado School of Mines. He previously served as the Undersecretary of Commerce for Standards and Technology as the director of the National Institute of Standards and Technology. Dr. Copan has served in a number of other positions in public and private life, including as the principal licensing executive for technology transfers at the Department of Energy and Department of Energy National Renewable Energy Laboratory. We welcome all of our witnesses. We thank you for appearing here today. And as is the rule of this committee, would you please rise to take the oath? Raise your right hand. Do you solemnly swear or affirm under the penalty of perjury that your testimony you're about to give will be true and correct to the best of your knowledge and information and belief? So help you God. Thank you. Please sit down. Let the record reflect that all witnesses did answer in the affirmative. For all our witnesses here today, some of you have been here before, all of you have seen this on C-SPAN. We'd like you to summarize what might be much more extensive comments into about 5 minutes. We won't cut you off mid-sentence, but we would appreciate getting to questions as quickly as possible. Your entire opening statements, plus additional information you may choose to give us afterwards, will be included in the record. So you will be much more complete to the studious staff than you are to the public here today. And with that, Mr. Cohen.
Thank you very much, Chairman Issa, Ranking Member Johnson, members of the subcommittee and staff for inviting me back to testify today. My comments focus on 3 SEP lawfare-related issues: transparency, intervention in the markets or subsidies, and global rate setting. And I echo Ranking Member Johnson's comments on the Chinese environment. My comments are directed to helping ensure that the U.S. system remains a leading system for adjudicating SEP disputes to support our innovative companies without compromising our values. Regarding transparency of the Chinese courts, I am generally referring to placing final court decisions online on the official Chinese judicial database. During the last decade, this minimal type of judicial transparency has been decreasing significantly. In the past, only about 50% of patent cases were published. That number has since decreased, and I can't give you the exact amount. The number of published civil cases has declined by as much as 2/3. Chinese SEP cases today have been withdrawn from publication, anonymized, delayed, or not published at all. This curated or perhaps censored approach makes it impossible to answer basic questions about China's IP system, such as China's compliance with international agreements, including the Phase 1 agreement. And the Phase 1 agreement, in fact, did nothing to advance transparency of judicial decisions. If there are to be any negotiations with China on IP, and I encourage them, a focus on transparency to better evaluate China's adherence to any commercial law commitment is essential. Next issue is intervention in the markets. China distorts its markets involving SEPs through subsidies for patent filings and grants, and for subsidies for attending standard-setting bodies, and even through awards. Patent subsidies had even been obtained by prisoners to mitigate their sentences. Some current subsidies. In Pudong, Shanghai, the subsidy is about $3,000 per patent grant. If a company wishes to establish a SEP patent pool, there's a one-time subsidy of about $160,000. In Shenzhen, there is a reward for high-value SEP patents with corresponding PCT applications of about $160,000. Subsidies have often exceeded the cost of the patent application. Patent subsidies distort markets and burden overseas patent offices with low-quality patents. They may lead Chinese courts to unduly focus on quantitative rather than qualitative basis for royalty calculations. They are leveraged to lower royalty rates. They burden companies with the additional expense of evaluating patent thickets of low-quality patents before they do business. Subsidies are also granted to firms for each proposal they submit to international standards bodies. These subsidies have led to a flood of low-quality proposals. We need to ask China to address the problem of IP and standardization subsidies and to ensure that it renews its efforts to focus on patent quality. Global royalty rates. China's longstanding efforts to set global royalties have taken various forms. The basic goal is for Chinese courts to set lower rates for FRAND royalties for implementation in China, thereby giving Chinese companies a competitive advantage over other markets. One of those efforts involves interference in the adjudication of SEP disputes by other countries. The Chinese courts deemed the filing of a U.S. Section 337 action against Huawei as an abuse of dominance under its antitrust law about 10 years ago. Chinese courts have also issued anti-suit injunctions to control actions by litigants in foreign courts. Such efforts are accompanied by extraterritorial civil jurisdiction, exclusive use of Chinese law for determining disputes, lower rate determinations for licensing to China, unique approaches to translating and applying FRAND, and efforts to regulate non-resident patent pools. These efforts, and I've only named a few, low transparency, extraterritorial jurisdiction, and patent subsidies, threaten the global territorially based patent system and the global standardization system by extending China's reach, providing preferential treatment to China-based companies, and disregarding the integrity of other countries' legal systems, including our own. Thank you once again, and I look forward to your comments.
Thank you. Mr. Baker.
Mr. Chairman and distinguished members of the committee, thank you for allowing me to speak today. I come from the trenches of IP warfare. u-blox is a small to medium-sized innovation company that provides wireless semiconductor chips, modules, and services that power the Internet of Things to reliably track, locate, and data connect everything. It's not voice-enabled, it's data connections. We participate in standards organizations and associations such as Save Our Standards, which represents companies in agriculture, healthcare, energy, automotive, artificial intelligence, and several other industries. u-blox modules allow devices to talk to each other with or without human intervention. We innovate and design the fundamental wireless connectivity components that can be used in any IoT machine or product that needs a wireless connection. You're going to find our modules in smart cities, water and gas meters, used with sensors for crop monitoring, robotics, aftermarket car alarms, industry floors, and much more. Even tracking adolescents or children for security purposes. That's how small these modules can be. Now, I thought it'd be useful to show you one. That's a module, the little white box you see here. This is a test board, certainly not that big in the product, but if I were to put power into this port, flip this switch, this will connect to any network. It will connect to your base stations as a cellular network. Don't be confused. This is the fundamental wireless connectivity that goes in every product, although, granted, it will be miniaturized. There is a data port here. It's a serial type port, but anything you connect to it, car, laptop, whatever need you have, put your data in here, and this device is going to send it onto the network. As you see, the modules are very small, and they're easily overlooked. Issues regarding module security threats and the emerging Chinese dominance in the US and IoT global markets, I think, has gone unnoticed. My intent is to bring to the committee's attention 4 things. One, there's a very real threat presented by Chinese IoT module manufacturers to US communication systems and Western manufacturers of IoT wireless modules. These may be companies you've either never heard about or rarely read about. You may recall similar security issues arose recently with Huawei and ZTE cellular base station products and handsets. Now, I'm not sure why, but IoT modules were not part of that discussion. They certainly should have been. They present an equal or greater security risk than did the mobile handsets. Now, appreciate that these modules can talk to each other. They don't need the base station, and that's part of the reason that security risk can be even higher. When you have machines talking to machines without human intervention, that's a concern. 2, there's the eventual collapse of Western wireless module manufacturers such as u-blox, and the loss of the $5 million global market due to Chinese companies having access to subsidies and centralized funding, as Mark just commented on. And for us, it's specifically the CCP 13th and 14th 5-year plan, where these subsidies and additional funds are being called out specifically as part of an overall strategy. As discussed in my written testimony, Chinese company market share and revenue growth now dwarfs Western companies. At u-blox, we've closely studied supply chains and what does it take to actually build this module, and we find Chinese companies selling the module at a profit for as low as $7.50, whereas a Western company can't build it for under $9, sans profit. Big question on how that happens without subsidies. Currently, Chinese companies are worried about the growing concerns in Western companies about the security and subsidies issues, so they're opening US corporation storefronts to go ahead and sell their modules, and they appear to be Western sourced. 3, there's an understanding of how increasing participation at international standards organizations, a company can manipulate the system. If you send enough engineers into a work group, as we have seen happen with Chinese companies over the years, you will generate more patents, more invention disclosures, and that will put you in a dominant position to then manipulate the entire FRAND promise. And last, I suggest the US take a leadership role that it's lost in patents and in the SEP-FRAND licensing debate. That will bring predictability and stability to IoT standardization for small and medium enterprises. SEP-FRAND is currently the Wild West. There are inspirational guidelines that we follow, but we all know how well those guidelines work when there's money to be made. They simply don't. And SEP-FRAND needs to be addressed, and it needs to be defined. In closing, I think it's imperative that the US protect national security and wireless IoT services and reject SEP licensing misconduct by any company. The US must take down the artificial fence that's been erected between SEP holders and SEP users. Standards were created to proliferate technology and protect patent holders. It's time to stop the SEP-FRAND gamemanship.
Thank you. Professor Cotter.
Chairman Issa, Ranking Member Johnson, and distinguished members of the subcommittee, I'd like to provide a brief overview of litigation involving FRAND-committed SEPs in what I view as the 4 leading jurisdictions: the United States, the United Kingdom, Germany, and, of course, China. So a little context, as you've already heard, some patents are essential to the practice of standards established by standard-setting organizations, such as the European Telecommunications Standard Institute. SSOs typically have policies encouraging or requiring members to license any such SEPs on fair, reasonable, and non-discriminatory FRAND terms, but they do not define what FRAND means. So one other thing to note is that patents are traditionally viewed as territorial rights. So a company may own a US patent covering a particular feature and also a portfolio of non-US patents covering the same feature. So as a result, when parties fail to reach agreement on the terms of a FRAND license, they could wind up litigating in any country in which products incorporating the SEPs at issue are sold. In the US, FRAND disputes make their ways to the court by different paths. So first, US courts have concluded that FRAND commitments can create third-party beneficiary rights, so an implementer may be able to assert that an offer to license on above FRAND terms is a breach of contract. Relatedly, sometimes either a SEP owner or an implementer may request a court to enter a declaratory judgment that the owner's offer is or is not FRAND. Another possibility is that a SEP owner will file a suit for patent infringement, and the judge or jury will decide what a FRAND royalty is for the patents in suit. So far, however, US courts have not seen fit to award injunctive relief in these cases under the Supreme Court's eBay decision. One possible workaround for SEP owners may be to seek an exclusion order from the International Trade Commission. But in a 2013 case involving FRAND-committed SEPs, the U.S. Trade Representative vetoed on public interest grounds an order that would have precluded Apple from importing certain devices into the U.S. Finally, U.S. antitrust law so far has not played a major role in these cases, largely because Section 2 of the Sherman Act is understood to forbid the willful acquisition or maintenance of monopoly power, but not its mere exercise or exploitation. Second leading jurisdiction is the United Kingdom. In the UK, these issues are typically litigated as patent infringement actions. And over the past few years, the UK courts have developed a procedure whereby if a SEP owner succeeds in proving that the defendant is infringing one or more valid FRAND-committed SEPs, the court will offer the infringer a choice, either be enjoined from practicing the technology in the UK or agree to be bound by the terms of a global FRAND license to be determined by the court. We've seen that happen in a few cases. Third leading jurisdiction is Germany. In Germany and other civil law countries, injunctive relief is often viewed as being a matter of right rather than equitable discretion. However, in the 2015 decision of Huawei versus ZTE, the Court of Justice for the European Union held that EU antitrust law constrains the owner of a FRAND-committed SEP from seeking injunctive relief unless certain conditions are met, one of them being that the implementer fails to express its willingness to license. German courts have interpreted this decision to mean that the implementer's willingness must be ongoing, and the end result is that in most cases, German courts find the implementer to have been unwilling and therefore have entered injunctive relief for the infringement of FRAND-committed SEPs. And the German courts have yet to actually establish the terms of a FRAND license. Finally, China. Since 2013, Chinese courts have presided over cases involving FRAND-committed SEPs, sometimes in the context of patent infringement actions or antitrust actions, or sometimes, as I understand it, as a sort of standalone cause of action. In recent years, Chinese courts also have expressed a willingness to determine the terms of global FRAND licenses where they believe there is a sufficiently close connection to China, and we had the first such determination of a global FRAND royalty just about a year ago in Nokia versus Oppo. Last thing, briefly, anti-suit injunctions. These have actually been around for a long time in the UK and the US. The application of them to SEP cases actually began in the US with the Microsoft versus Motorola case in 2013, but more controversially in 2020, Chinese courts entered ASIs in 5 SEP cases, forbidding parties from litigating parallel actions sometimes anywhere else in the world. That seems to have gone away to some degree. Now, I don't think we've had any since 2020 for a variety of reasons, but of course that could always be resurrected.
Thank you. Dr. Copan.
Chairman Issa, Ranking Member Johnson, members of the committee, and distinguished participants. It's a privilege to testify on critical issues for U.S. innovation leadership, global economic competitiveness, and national security. It's my honor currently to lead research and technology transfer at Colorado School of Mines, a top-tier U.S. research university rated in the top 3 engineering programs in America. I recently served our nation as director of the National Institute of Standards and Technology, and prior with 2 of the U.S. Department of Energy national labs. For my leadership experience in public and private sectors, as a corporate executive, entrepreneur, and investor, the requirement to have clear, enforceable intellectual property rights and the right to exclude others is foundational to innovation success. Investors must confirm that an organization's IPRs will secure a protectable market position and provide pathways to achieve returns on investment as part of the justification to take on substantial investment risk. Strong IPRs enable innovators to advance technology leadership, incentivize investment, and create value, including from inventions essential to global standards. The United States is at a critical juncture regarding the future of American innovation leadership for the world. Our economic security and national security are closely intertwined with the reliability of the protections afforded by our IP and innovation system. The foundational strength of U.S. IPRs, as established by the framers of the Constitution, must continue with the enforceability of the rights of inventors in the U.S. and abroad, together with the rule of law and respect for private contracts. The U.S. must once again lead the world by example through the development of IPR policies that support innovation at home and across jurisdictions. Reliable IP rights and contracts that are respected globally include the key role of standard essential patents, and the U.S. must demonstrate leadership in foreign markets, including with the EU and China. This includes restoring the ability of rights holders to obtain injunctive relief and to avoid willful infringement and documented holdout by parties unwilling to enter license agreements with rights holders under FRAND terms. Where such negotiations fail in a free market economy, knowledgeable American courts can provide resolution with expertise and wisdom. All are essential for rebuilding and maintaining U.S. leadership in globally relevant standards today. The U.S. leads the world in key standards and consequently is a net exporter of innovation. Reliable IP rights, licensed development, and manufacturing partners enable trusted global supply chains and value creation for consumers and for shareholders alike. The mobile telecommunications sector contributes an estimated total economic value of more than $4.8 trillion to the global innovation economy. Technology innovators, including holders of SEPs, gain returns on their investments in R&D and standards engagement through licenses and royalty payment, in addition to product and services sales. The revenue flows from commerce in intellectual assets contribute positively to the U.S. trade balance, with Chinese companies contributing over $70 billion in net IP payments to U.S. entities in 2020. However, there is widespread unlicensed technology use in China of innovations and IP assets owned by U.S. entities. Further, China's government has weaponized its legal system with a wide range of patent and competition law tools, price controls on international entities, forced technology transfers, and by providing selective legal protections and incentives seeking to advantage Chinese companies. There is a concerning movement away from market-based negotiations and valuation to government-controlled price regulation for standardized technologies. The EU has proposed a massive new regulatory regime toward government control of SEP prices. The Chinese Communist Party has followed suit, issuing guidelines that would apply its antitrust laws to SEP licenses to benefit Chinese entities. Supported by the Chinese government incentives and legal actions, Chinese technologies companies are gaining ground. As we look to rebuild America's advanced manufacturing base with a trained domestic workforce and trusted, resilient supply chains, the U.S. must build upon the strengths of our free market economy and a reliable intellectual property and innovation system that continues to lead the world. I'm encouraged by some of the legislation proposed to strengthen the U.S. innovation system, including the Bipartisan Patent Eligibility and Restoration Act, the Promoting and Respecting Economically Vital American Innovation Leadership Act, and the Realizing Engineering, Science, and Technology Opportunities by Restoring Exclusive Patent Rights Act of 2024. Thank you to this subcommittee for your important work towards securing the technology and innovation leadership for U.S. economic and national security. I look forward to answering any questions you may have.
Thank you. I thank all our witnesses. We'll now go into 5 minutes per side of questioning, beginning with the gentleman from Kentucky, Mr. Massey.
Thank you, Mr. Chairman. I think it's important as we kick this off to talk about what SEPs are, or SEPs, Standard Essential Patents. Mr. Cohen, are these government creations, or were these created by private industry, this nomenclature and this grouping of patents?
They're predominantly created by private standards development organizations, which have private sector participants, although there are government standards, particularly in China, but also in the US.
Okay, thank you very much. Dr. Copan, you joined several former administration officials, former, I say, to send a 2023 letter to the European Commission opposing the EU's draft of SEP regulation that would cap royalties for licenses of standard essential patents and create separate centralized proceedings at the EU IP office. Do you continue to have concerns about the efforts of foreign competitors to regulate our IP?
I do, Congressman. Those concerns that I also included in my oral testimony are with respect to the overreach of governments to regulate free trade and fair commerce and standard essential patents. And I stand by that joint letter.
Aren't a lot of the patents created by U.S. entities? And isn't it sort of insane to let countries, not just China, I mean, we're here ostensibly about China, but the EU is talking about doing the same thing. Because these patents are so important to things like national defense or our own competitiveness in the world economy, isn't it kind of crazy to go along with this scheme in the European Union that would let them effectively nationalize our IP by setting the rate that could be charged globally for it?
It is a huge concern. The United States' sovereignty over its intellectual property rights and the value that U.S. innovators create in global markets is something that needs to be part of a free market economy. And we know that sophisticated companies, developers, and implementers of technology have the guidance in fair, reasonable royalties that are non-discriminatory and enabling the practice of commerce across borders without government interference.
Well, I've heard some arguments that SEP, standard essential patents, are so important that you shouldn't be able to get injunctive relief, that the owners of the IP shouldn't be able to get injunctive relief. Do you agree with that argument?
No, sir. Intellectual properties that are standard essential patents are patents and deserve the same protections as the intellectual property rights of innovators in the United States, and indeed protections in jurisdictions elsewhere where intellectual property parallel protections exist.
Let me ask you, you mentioned some legislation that you were a fan of. What could we do in our own country with our own IP laws to improve American competitiveness and improve our national security?
Definitely the improvement of clarity with regard to patentable subject matter is an important feature. Creating greater certainty in our courts of the basis on which decisions are made, in particular with respect to standard essential patents. And I also believe it's very, very important for the United States to continue to lead by example, as I had indicated in my remarks, that the United States has a fair and reasoned process for adjudicating issues in our courts that enable rights holders around the world to trust the U.S. judicial system and that they know that the United States sets the highest standard globally for fairness in intellectual property matters.
Mr. Cohen, I want to give you a chance to answer the same question. What do you think we could do here to, with our own IP laws to improve the signal that we send to other countries that we're the best country for developing IP in?
Well, I certainly agree with Dr. Copan's perspective on strengthening the domestic legal system in terms of patentable subject matter, availability of injunctive relief. There's another aspect in terms of the competition globally for jurisdiction over FRAND disputes and parallel disputes that arise. So we could find that even if we have the best system in the world, China can fast track its litigation so that a case will be resolved on appeal from beginning to appeal within 9 months, according to the Chinese civil procedure law. At that 9-month stage, we haven't even finished discovery in a U.S. district court. So having expedited procedures, perhaps specialized tribunals, although I'm not a big fan of that, but at least slimming things down so that people can get a quick relief, and having better assessment of the foreign competitive challenges. I'd like to see our Solicitor General from time to time appear in SEP cases to say whether a particular jurisdiction is fair or the potential disadvantages. I know one case in California where the judge was quite clear that by the time he renders a judgment in that case, China will already have exhausted its appeal. We have to make our system more attractive in the global competition for litigation on FRAND matters.
Thank you both very much. I agree with you on injunctive relief here domestically. I yield back to the chairman.
Right. Briefly, Mr. Baker, did you have something else to add? You took copious notes.
Yes, if you don't use injunctions correctly, FRAND is absolutely meaningless. Injunctions were used because of a characterization called holdout, where a company like u-blox might not take a license. Unfortunately, if you look at especially foreign injunctions in Germany and over in China, what you'll find is there's no FRAND analysis. It's the fact that, all right, here's something, we're going to assume it's FRAND. If you don't take that license, we will issue an injunction. You can throw FRAND out the window with that. Also with standard essential patents, the problem that you come up with is it used to mean, and I was there in the work groups, and I worked with DG Grow on why the entire competition SEP regulation is coming out. It used to mean technical essentiality. Take it off the board, it doesn't work. Take the patent out of the module, it doesn't work. That's changed, and it's been manipulated, and that's the manipulation we're talking about. What we need is clarity in both what FRAND and what a standard essential patent definition means. Now, you're trying to control both.
I have to keep it to brief. We'll continue. Mr. Johnson.
Thank you, Mr. Chairman. Dr. Copan, could you enlighten us on how SEPs ensure worldwide interoperability?
Thank you so much, Ranking Member Johnson. The technical committees working on international standards bring together science and engineering experts to consider the broad dimensions of a standard, for example, in advanced communications. The organizations participating in those standards processes provide data, provide insight to the rest of the committee with respect to the technical operations, and ultimately, intellectual properties that underpin those features that are important to interoperability on a global basis, as you had indicated in your comments as well, enable the inventor, the rights holder, to participate in the standard setting process, and then also through providing access to those intellectual properties on fair, reasonable, and non-discriminatory terms, enables the actual practice then of an interoperable standard.
Thank you. How do international standards setting organizations go about designating SEPs? And why is that process important?
It is indeed a very important consideration. It is an analysis that's carried out by the committees on contributions to the standard itself and to the merits that are delivered by the intellectual property, by the invention to the standard on a relative basis. And so there is a technical evaluation that's done of essentiality by the technical committee itself.
Thank you. Mr. Cohen, in your written testimony, you told us that you believe that the WTO remains a viable option for airing our concerns and bringing multilateral attention to areas where China has departed from international practice. What SEP disputes do you expect to see at the WTO over the next 5 years?
That's a bit of a crystal ball exercise, but certainly there's been a lot of frustration about the levels of the royalty rates that Chinese courts determine. I tend to think that Chinese practice of giving a preferential rate to a China-based company violates national treatment or most favored nation treatment obligations, which are, of course, critical to the WTO generally. So that would be one issue that I think is extremely important. There continue to be serious concerns about transparency, and I think those need to be clarified with China, either diplomatically or at the WTO. The extraterritorial nature of China's CEP litigation practice is being raised by the European Union at the WTO. The global rate setting is another level which deprives countries of their own sovereign courts to adjudicate their own sovereign patents. And I think that raises another level of concern about CEP litigation and kind of an over-national focus by China to extend its reach globally.
Thank you. Professor Cotter, how does the absence of transparency in Chinese courts impact FRAND rate setting in other jurisdictions?
You want to turn your mic on, please?
Right. There, is that on? Yes, okay, sorry. I think Mr. Cohen is correct that it is more difficult to find the Chinese cases than it is to find cases in other major jurisdictions, such as certainly the US, but also the UK and to a great extent the European countries as well. So I think it would be very helpful if those cases were more readily available, and if they were available in some format where they could be translated either officially or at least at some high level so that others can actually understand what they say. I don't speak or read Chinese, so I am always reliant on translations or reports of these cases, and so I think it would be advantageous if the cases were more readily available to the community generally.
Thank you, Mr. Chairman. I'll yield back my 3 seconds.
Thank you very much. With that, we'll go to Mr. Fitzgerald for 5 minutes.
Thank you, Mr. Chair. Mr. Baker, Congress was just recently briefed about Sol Typhoon and very concerning issues related to just how far that the CCP has kind of penetrated into the U.S. cellular networks. Do you have concerns regarding security and the vulnerabilities of Chinese technology? Obviously, there's an overall concern, but specifically in our cellular, the modules that we use here in the States?
Yes, there's an overall security concern, not just in cellular, but also there's a hybrid coming along which merges cellular with satellite. And the two together, there is a security concern about the information that you can actually take. Appreciate I said that these modules can talk to each other, which means you can bypass a base station. If you park your security software in the base station, you're probably not going to know that the machines are being corrupted.
What could we do to protect the companies that we've all become very familiar with, the big cellular phone corporations?
Yeah, I think the corporations are capable of protecting themselves.
Okay.
Especially I came from Qualcomm, was where I spent many, many years, and we're perfectly capable of taking care of that, given the opportunity to do so.
Very good. Dr. Copan, this is more of a general question, and I know we've already had kind of a couple of others that dug down into this, but the SCP portfolio is owned by Chinese-owned companies like Huawei. So what are the risks associated with amassing such a portfolio of patents that also include the U.S. patents as well?
Thank you, Congressman. The risk that we've seen in the application, in particular in the courts in China, is to take a numbers-only approach. And regardless of the actual contribution of the intellectual property to the practice of the standard, by flooding the intellectual property system, in particular in China, and providing a massive stack of patent documents, we have seen the Chinese courts actually favoring that type of approach rather than what we've seen in the UK courts or in the US courts that take a much more detailed approach toward understanding the actual contribution of the intellectual property to the practice of the standards.
Very good. Professor Cotter, can you please describe how the injunctions against the American companies sought by foreign companies in foreign courts hurt the U.S. economy? How can we draw that line?
Well, there are a variety of approaches, a variety of perspectives on whether injunctive relief should be granted generally for SEPs, and the German courts and probably also the Unified Patent Court within the European Union take the view that injunctive relief is more a matter of right, and so you usually get an injunction in those places. I mean, the UPC has just started up, but in Germany, certainly you usually get an injunction. That puts tremendous pressure on the implementer to then reach a settlement. And maybe that is appropriate if the implementer is holding out, is delaying the resolution of the case for strategic advantage, but it also means that in many cases, I believe, the SEP owners are using the threat of injunctive relief potentially to extract an above-FRAND license. And so part of this goes to why these FRAND commitments are required in the first place, and that is to constrain SEP owners from exercising undue market power, raising prices, and ultimately harming consumers. So the IP system has to be about balance, and I think that some degree of flexibility in awarding injunctive relief is appropriate. That's what we have in the US. It's also what we have in the UK. And I would encourage other countries to follow that path rather than to making injunctive relief for SEP cases mandatory.
Well, I'm bringing up the UK. So, is there an articulated or a specific type of framework in the FRAND determinations? What are your thoughts on that framework, and do you believe there's a concern that it's probably going to lead to greater instances of venue shopping in the UK, right?
Well, I think the UK went to a place where I didn't expect, well, let me rephrase that. In 2017, the UK became the first country, I believe, to set global FRAND royalties without consent of both parties. That was the Unwired Planet case, and I and many people were critical of that because it seemed like a bit of overreach. On the other hand, the last couple of times they've done that, the rates that they have set have actually been relatively favorable to the implementers. So if anything, they might be more attractive to implementers now than to SEP owners. I will say that I think the UK judges do a very decent job. They're very thorough, very detailed, very well respected. So in some ways, the UK model, I think, has proven to be quite a good one. But the doctrinally, the idea is you'll either be enjoined or you let us set a global FRAND rate. But one predictable consequence of that was that other countries such as China would then follow suit and do the same thing.
Thank you. I yield back, Chairman.
I thank the gentleman. We now go to the ranking member of the full committee, the gentleman from New York, Mr. Nadler.
Thank you, Mr. Chairman. Dr. Copan, American companies' ability to invest in R&D ensures that our patents 10 years from now are competitive with Chinese companies. How can investments in American R&D affect our national security over time?
Thank you so much for that question, Congressman. The ability of the U.S. to invest from the private sector and to see value creation in the global marketplace is an essential part of the workings of a global economy. These connections, however, between national security and economic security are very, very clear and direct at this time. And so the health of the U.S. corporations that have a global play, and also the ability to license under FRAND terms in ways that truly provide returns on investment for U.S. industry to continue to drive forward research and innovation and lead the world is essential also for national security.
Thank you. Mr. Cohen, we have seen the Chinese government use anti-suit injunctions in the past in a manner that I have characterized as bullying, but then seemingly move on after being challenged on the global stage. But moving on does not mean that they have stopped abusing the legal system, right?
Yeah, moving on for China in this case means I believe that the EU WTO case forced China to at least put a pause on anti-suit injunctions, not to stop them entirely. What we've seen is the evolution of judicial practice towards global rate setting and greater extraterritorial reach of the courts. So we're hardly beyond the problem of China setting rates for SEPs outside of its territorial jurisdiction.
Let me ask you a question that you may have partially answered just now. Can you describe some of the new tactics the Chinese government has adopted to reach the same ends? And given that the Chinese government is clearly skilled at taking advantage of different legal regimes as needs arise, what would be an appropriate response from the U.S. government in conjunction with our allies?
Well, let me begin by the second part of that question. I think the appropriate response, if possible, is to be as multilateral as possible. I think that could mean using the United Nations or negotiating through vehicles like the IP5 or the USPTO with the other four largest patent offices, or engaging our antitrust authorities also to engage with their Chinese counterparts. The issue is the continuing, kind of in Chinese there's a saying, you have a policy, I have a counter policy. And what we've seen in China is the continual evolution of counter policies that rarely get to the bottom line. And I think that's part of a problem with the WTO itself, because you can't really amend your complaints at the WTO. You have to file another complaint. So that's a limitation, and I think we really need the focus of all our trading partners on this industrial policy approach to FRAND and SEP rates.
Should we try to get the WTO to allow the modification of complaints that you just said?
Yeah, I think that would help, frankly, because otherwise we're filing disputes on yesterday's issues.
Thank you. Mr. Cohen, I understand that the Chinese government's approach to dominating standards has included subsidies for patent applications for technology related to standards. Can you elaborate on this practice and describe its implications for what kind and how many patents Chinese companies might get?
That's a great question, and the numbers are in the thousands, if not tens of thousands. And it's not limited to SEPs, but at least in the SEP area, it's a bigger focus of litigation. It's resulted in overall a lower quality for Chinese patents. It imposes a burden on patent offices because, as any skilled bureaucrat knows, they have to use their end-of-year money. And if they have subsidies at the end of the year, then everybody wants to file to get those subsidies. And we've seen lower quality Chinese patents in the last quarter, in the fall. In fact, I joke sometimes that if China wants to improve its innovative ecosystem, they just have to ban autumn. So what we've seen is China using that quantitative advantage to achieve an advantage in the courts, and sometimes antitrust agencies frequently rely on patent counts, and they don't want to go through the more laborious task of qualitative analyses.
Thank you. And finally, how does this practice affect global rate setting, and what is the best way to ensure that rates reflect patent quality rather than quantity, as you just said?
Yeah, I think I've already partially addressed that. It clearly addresses rate setting, particularly by agencies that rely on counts. I think the more we bring new information to the table, the PTO did a great report, I think, about 4 years ago on the quality of Chinese SEP patents. They also did it on trademarks, and they pointed out the pernicious effect of patents, of subsidies on that, and I think we need to do more of that, bringing it out into the open air, because it's not discussed enough.
Thank you, and I yield back.
I thank the gentleman. We now go to the gentleman from California, Mr. Kiley, for 5 minutes.
Good morning. Mr. Baker, if I could start with you. I think you made a comment about how we need more of a leadership role for the United States when it comes to standard-setting organizations. So I wanted to ask you just what are the ways that we could do that? There are examples of standard-setting organizations that have managed to keep the Chinese influence at bay through appropriate governance measures. So maybe that's one route. Or maybe in other cases where China is gaining influence legitimately, how could we step up our involvement in these organizations, provide incentives for participation in them in order to match their influence?
That's an excellent question, because one of the things that happens with U.S. corporations that are not subsidized, when your budget goes down and your returns go down, you reduce your staffing at standards organizations. It doesn't occur with Chinese companies. When they're subsidized, they increase the number of individuals. As far as participation, remember, it's a technical standard. The idea of more engineers is a good thing. And I will disagree with one thing. The standard essentiality of something that's put into a standard is not addressed by a work group. I've been in the work groups, and that is specifically excluded. The technical elegance is what's included in the standard, and you sort out the septness later. The problem is nobody's sorting out that septness. It's a big question mark. So as far as participation, a great start would be having an initial threshold as far as the number of participants that could represent a company at a standard, changing voting rights so that the voting rights are reflected based upon an individual company gets one vote, and other such procedural methods. Some standards have implemented them, many others have not.
And so how could we sort of have more of a voice in setting those rules of governance?
That's a difficult question, because the whole idea of the standardization setup is to have it privatized. Under the Western philosophy. In China, it's slightly different. And Mark, you know more about that than I do. But as far as government being able to regulate it, I think there are certain programs where there is a role for government to play in trying to figure out the staffing levels for particular standards.
Sure. So let me revisit this, this question of sorting out the septness, as you put it, which refers to, I believe, whether the patent is truly standard essential. And you made a comment earlier about how true essentiality was a matter of whether the device needs to have that technology in order to work. But that seems maybe not quite technically the case. Isn't it a matter of whether you need to practice the patent in order to achieve compliance with the standard? In which case, having a standards essential patent is kind of like a tautology, because once it's in the standard, you have to use that technology to achieve interoperability. So which is it?
Yeah, Congressman, it's actually, you're describing it correctly, but the technical essentiality is part of the interoperability of the standard. If you take out that technical essentiality, it's not going to be interoperable.
Right, so there's the question of whether a technology is necessary for a device to work, and then there's a question of whether it's essential to achieve interoperability. But the latter question, is just a matter of the choice that was made in the standard setting process, right? Different choices could have been made to use different technologies to achieve the same level of interoperability. So is it your argument that that essentially renders it not a set patent, or does that go to the setting of FRAND rates because there exist viable alternatives, not to practicing that particular standard, but rather to achieving some level of technical interoperability?
You're actually hitting on a very good point, because there are different parts of a standard. There can be the main part of the standard, and there can also be appendices to the standard. So if you're talking about what is the most technically elegant way to achieve something, given all of the engineering parameters around what that standard seeks to achieve, that would be what's technically essential. That doesn't mean a different way of doing it in a different part of the standard would not yield standard essential patents if you implement that part of the standard.
All right, interesting. Yeah, it seems like an area worth exploring. I guess that part of the issue is that there's just such a mess in terms of what the standard is. Well, probably a bad word to use standard again, but what the framework is for setting FRAND rates, that it's created all of this confusion and uncertainty. But Dr. Copan, I wanted to also give you an opportunity here, because I was glad you mentioned the PARA, which I've introduced, a piece of bipartisan legislation, bicameral, which would go a long way towards clarifying subject matter eligibility, creating more certainty for those who are looking to innovate. Could you talk a little bit more about how that is particularly relevant to the general theme of today's hearing, which is the ways in which China has come to use dominance of intellectual property as a major tool against the United States?
Thank you so much, Congressman Kiley, and grateful for your leadership in PARA. The opportunity to provide greater clarity on patentable subject matter is absolutely important in the United States with respect to the enforceability of IP rights, as well as to understand how they read upon the practice of a standard. And that clarity benefits not only the United States practitioners, but companies from other nations as well, seeking to access the United States market.
Thank you. I yield back.
Thank you. I now ask unanimous consent that three letters to the committee in support of today's hearing be placed in the record. The first is from the Coalition Against Socialized Medicine. The second is from the organization, the Council on Innovation, C4IP, and the third one is from the App Association. And without objection, all three will be placed in the record. We now go to the gentlelady from North Carolina, Ms. Ross.
Thank you, Mr. Chairman, and thank you to all the witnesses for joining us today on this very important topic. I represent North Carolina's Research Triangle, so I know firsthand that our nation's leadership in technology and innovation depends on strong intellectual property protections. Among the most critical tools in this regard are standard essential patents. SEPs, the backbone of technologies like 5G, Wi-Fi, and advanced video compression, allow companies to build interoperable products globally. American innovators, as we've all discussed, then license these patented technologies to Chinese and other foreign implementers, and the royalties from these licensing agreements account for a significant share of the U.S. innovators' R&D and positive trade balance. As we've heard, China is actively undermining U.S. leadership by devaluing these patents, directly harming American innovators and weakening their ability to compete globally. There are also national security threats in this situation. These tactics threaten innovation and risk ceding U.S. leadership to for emerging technologies to China at a time when the State Department report shows that the U.S. already lags behind China in 37 of 44 key tech sectors, from AI to biotechnology. We need to defend the ability of American innovators to license their patents under fair, reasonable, and non-discriminatory terms, FRAND, as we've been discussing, and push back against foreign efforts to impose artificial royalty limits. Further, we must condemn China's abusive practices, including judicial overreach, that harms our IP holders and the integrity of international agreements like TRIPS. By doing so, we can preserve the incentives that fuel technological breakthroughs and maintain our edge in global standard setting. As we face competition from China, defending intellectual property rights is both an economic and a national security imperative. Dr. Copan, in a 2022 comment you co-signed for the Renewing American Innovation Project on multi-agency SEP policy, you noted how devaluing U.S. patents is akin to subsidizing tech transfer to China. How should Congress, the administration, and the private sector ensure that companies play a leadership role in R&D and standard setting for next-generation critical technologies? For example, does the U.S. need to increase its leadership in standard-setting bodies and voluntary standard development organizations?
Thank you so much for that important question, Congresswoman Ross. It is absolutely essential for the private sector-led process in standardization to be well understood as a national security imperative of the nation. The conversations here today have discussed the importance of encouraging U.S. industry to maintain their presence and to contribute actively, also in partnership with the U.S. government, with organizations such as the National Institute of Standards and Technology at the table with a role as partner and supporter to the private sector. The opportunity is absolutely essential for the nation to continue to have enforceability of intellectual property rights on a global basis, to work with trade organizations and also with WTO to ensure that the United States position is supported and that the erosion that we have seen of intellectual property value by the actions taken by the Chinese courts is condemned by the United States and like-minded nations.
Thank you. And then Professor Cotter, I know we only have a few seconds left, so I'll make my question short. You talked about what goes on in courts around the world. But when it comes to setting countries' royalty rates, would you agree that it's more efficient and fairer to let IP innovators and implementers negotiate a rate at arm's length as opposed to having outside intervention?
I would say that ideally negotiations are best, but it is often the case, particularly in this particular sector, that the negotiations cannot take place before the implementers are locked into particular technological choices. And so when that happens, I think there is a necessary fallback for the courts to make decisions in appropriate cases when negotiations fail.
Yes, correct. Thank you so much.
Thank the gentleman. Now go to the gentleman from Virginia, Mr. Klein, for 5 minutes.
Thank you, Mr. Chairman. Mr. Baker, I'm looking at your testimony about what should be done and how to regain leadership in the SEP-FRAN licensing process to make sure all SEP holders receive fair compensation for the use of its actual SEPs by all SEP implementers. And it's your testimony that both China and the EU have proposed oversight to remove the cloak and veil from SEP-FRAN licensing, provide guidance, and level the licensing playing field between SEP holders and SEP implementers. How does that give the Chinese a strategic advantage to remove that cloak and veil?
I don't necessarily agree with the process by which either of those entities are approaching the subject matter, but at least they're making an attempt to address how you identify a standard essential patent and also FRAND. Remember that FRAND commitment, and Mr. Copan, I think, said about honoring contractual rights. When a patent holder, a SEP patent holder, makes an agreement to participate in a standard, they get a quasi-monopoly, which proliferates not only the standard, but also the use of their patent, which means they're addressing a much broader market. So the excuse me, the ability to actually define what is a SEP and also give some parameters, some guardrails around what FRAND means, I think those are advantages.
Now, your company manufactures modules for standards-compliant communication devices. Does your company pay licensing fees for SEPs as a result?
Yes, we're a proactive licensor, and one of the biggest frustrations we have is trying to license from Chinese companies such as Huawei and ZTE.
And do your Chinese-based competitors pay these licensing fees?
Nobody really knows, but I would say no, based upon the fact that they're selling a module, as I stated, that we can't even make it at, and they're making huge profits.
And so, obviously, that has a significant impact on your business when they're making these profits.
I would say that it's probably driving Western module manufacturers out of business. So if you want to have only Chinese providers of modules, that's the path you're on.
And when we consider what's happened recently with Chinese essentially intervention in the cell phone technologies and for lack of a better term, hacking into the cell systems of American companies, the pushing out of every other kind of manufacturer, I mean, this is getting worse, not better, correct?
Correct. I should add exponentially worse. It's an ever-evolving rate.
And so your company is an SME that implements a number of technical standards, and you have firsthand experience in the licensing of SEPs. And you walked us through the process of licensing SEPs for an SME. How do you assess the value of a particular SEP during licensing negotiations?
Yeah. Now, appreciate our method may not be one that's followed by every company. And the reason for that being a small, medium-sized company, we don't have a deep pocket to do a tremendous amount of analysis. But what we do is a statistically significant analysis. So when presented with a portfolio of 1,000 patents, we'll take 100 of them. We will independently look at those to determine both internally and through external experts on whether or not they truly read on the standard. The declaration that's filed by a patent holder, a SEP holder, into a standards association has zero relevance to its actual SEPness. So we actually undertake that burden to do that. That's unique in the industry. And we do it as it's an overhead cost, but that's the only way we can have an idea. One, are we actually using the patent in our product? And secondly, what would be a reasonable valuation, because are the patents you hold incremental improvements? Or are they something truly monumental and early technology like millimeter wavelength coming out of 5G? That's brand new stuff. Right. That's going to be pricey.
And is there a way that you envision that we can improve the efficiency of this system? Or
if there was an ability to actually have a determination of whether or not close the loophole. You have a declaration put into a standards group where I believe it's going to be standards essential. You've got a patent over here in another dynamic system going through the patent evaluation system at the USPTO. The two never come together to determine SEPness. So you don't even know if that originally filed belief declaration has anything to do with the actual technology in the patent issued. So one thing that would be good would be to harmonize the issued patent with that original declaration and see if that technology actually made it into the standard.
Thank you. Yield back.
Thank you, the gentleman. We now go to the gentlelady from Pennsylvania, Ms. Dean.
Thank you, Chairman Issa, Ranking Member Johnson, and of course to all of our witnesses today. Thank you for your expertise and for sharing this information. I'd like to go back. In a former life, I was a professor of writing at LaSalle University, and I really emphasized to my students the value of plain English. I can't even say it, plain English. So for the non-technical IP and technology folks out there, can we go back and tell us, what is a SEP? I'm laughing because you talked about SEPness. I never even heard of such a word, excuse me, for my ignorance. But could we go back for everyday Americans? What is a SEP? What are standard essential patents? And what's the criteria to become one? Maybe Mr. Copan? Dr. Copan?
Thank you so much for that question. And I appreciate the focus on clarity in writing and communication, and thank you for raising that. Patents provide innovators the ability to practice their invention in the marketplace and the ability to exclude others. In the case of SEPs, the inventor agrees to make that invention available to everyone who wants to practice a standard that would also be available then on fair, reasonable, and non-discriminatory terms. So it really is a commitment to make an invention broadly available to those interested in practicing.
Thank you. I appreciate that.
Dean, I'm sorry.
Yes, thank you, Mr. Baker.
I'm going to make this very simple. If you have a car and you take the tires off it, it doesn't work. Those tires are standards essential to the operation of the car. It's that simple. It's not a long definition. I was there when we wrote the policy guidelines. The language was simple, and it's currently being totally manipulated on what the original intent was by other people taking that simple language and trying to tell us what it means. I wrote the darn guidelines. I can tell you what it means.
That's very helpful. Anecdotes like that are very helpful to me. Mr. Cohen, we've heard arguments today, and I'm following up really on what Mr. Massey was talking about, that SEPs are so important to certain technologies that SEP holders should not be able to obtain injunctions or exclusion orders. But doesn't that run the risk of devaluing U.S. IP rights? Why shouldn't SEP holders have the same rights as other patent holders to enforce their IP in court?
I think Professor Cotter has given a brief explanation of why there's a different kind of balance with regard to SEPs. That is, that a SEP could be abused to extort an exorbitant monopoly rate when it should be made available on fair, reasonable, and non-discriminatory terms. So if in theory, if you violate that obligation in negotiation, maybe you should be deprived of the right to an injunction, but you should still be entitled to a robust royalty or whatever the appropriate royalty is. That's kind of the trade-off for inclusion of the SEP in what is more or less a public good, which is a standard. Now, having said that, that calculation, which was first expressed in a case in Europe called Huawei versus ZTE, can easily be abused. What constitutes good faith negotiations? How much do I have to disclose? What if the implementer delays and delays for years and years? If in a world such as China, where they insist on equality in rates, shouldn't I disadvantage the party who is delayed and delayed in coming to the table and negotiating? It shouldn't only be one-sided on the side of the inventor or the patent owner. You have to also look at the behavior of the implementer.
Do you have any comments on a bill that I'm a part of with Representative Moran, the Restore Act, which I think was talked about before I came into the hearing? I apologize for missing that. It would provide patent owners who have proved infringement in court the rebuttable presumption that they are entitled to an injunction to protect the patent. I believe in strong patent rights and strong IP rights. They are essential. Do you have an opinion on Restore?
Yeah, well, I can say that it severely disadvantages U.S. courts in the competitive battle to assert jurisdiction over FRAND disputes, to rarely have an injunction available when there is infringement, including when there is delay. And it particularly disadvantages those companies that may not be implementing, that may simply be engaged in licensing the patents. And we should keep in mind that the U.S. is the largest a licensor of technology in the world by a long shot, and a large part of those licensing agreements, particularly in markets like China, are to unrelated parties, so it's not General Electric to its subsidiary, it's a Qualcomm to a Oppo, or whatever the case may be. So this is really important for the innovative capacity of U.S. companies to derive the appropriate amount of revenue. So I believe that I support this proposal to go back or have a presumption of availability of injunctive relief.
I appreciate that. And Mr. Chairman, thank you. I yield back.
I thank the gentlelady. Now go to the gentleman from Maryland. As long as he promises not to mention the Army-Navy game, I will grant him 5 minutes.
Thank you, Mr. Chairman. I've ribbed my governor enough about that game, so I'll leave it at that. Just to follow up on what Ms. Dean just asked, I think it's Dr. Copan, you mentioned the Restore Act in your written testimony. I believe you in your oral testimony as well. I was curious about your answer to Ms. Dean's question about the view about that bill.
Yeah, thank you so much. And indeed, I did mention that in my testimony, the important step forward that represents for U.S. innovators. I do believe that it is important to provide that kind of position of strength for the United States innovators to know that they have the ability to take action in support of their invention and to deal with bad behavior in the marketplace, those who are holding out, and indeed to have clarity also in the courts of the ability to move forward with injunctive action when other remedies fail.
Thank you. Mr. Baker, I want to go back to your testimony. You said, well, I'll phrase it as a question. How do we keep Western module makers in business? Because I think your testimony was the way things are moving, they will be forced out of business in relatively short order.
Leveling the playing field. We're a component manufacturer. We do not operate at the end product level. So leveling the playing field with predictability within the marketplace so that we know that when we are making a component, we not only have direct access to patent rights, which allows us to innovate. Because when you have this module that's standard essential and you're using it, you then have to take this module and you have to integrate it into whatever the device is, whether it's a car alarm, whether it's a tracking device. So we are innovators also. We need direct patent rights, which means a direct patent. If you go ahead and you do just end product licensing, what you make us is a commoditized producer and manufacturer of these products. That only serves the Chinese purposes even more so because of the way that they actually do business. But leveling the playing field and requiring everyone who is participating and using those patents to have predictability in how much we will need to pay for the patents in an aggregate form, and also what is the true value of the collective standard essential patents used by that product. That would go a long way to keeping us in business.
Let me generalize on your answer there, because I think there have been a number of comments in the testimony about how to deal with the activities of the Chinese, and how to sort of address some of the misconduct. But they are frequently, you know, we're going to make efforts, we're going to pressure them, we're going to join different organizations and exert, additional influence. And not to be cynical, but I don't know that they're always responsive to those sorts of things. What actual sorts of legal and economic leverage do we have that we can assert in order to force more egalitarian behavior or more a level playing field of behavior, so to speak, with respect to the way China's handling these issues?
Yeah, well,
I'll start with Mr. Cohen, I guess.
Yeah, it's a great question. It's one that I think of constantly. Obviously, one response is tariffs. So, you can, and that's something that I think President Trump is probably going to look at.
That's timely, yeah.
So that
elaborate on that a little bit. What's your take there?
Well, the problem I have with tariffs is that if you start imposing tariffs for an IP-related issue, it's going to invite retaliation by China, perhaps on our own IP rights in China. So I'm concerned about China's capacity to cross-retaliate. And we have an IP system that, to this day, basically treats every party appearing in a U.S. court, foreign or national or local, equally. And so we begin to erode that system. We have to really think of the global consequences to eroding that system. And that concerns me, because we're seeing the erosion of MFN concepts and tariffs. Is IP next, and what are the consequences for that? That's something to think about.
Let me go to Mr. Baker.
Yep.
Look, I have to agree with the tariffs also, although we are not strong supporters of subsidies. If we're going to level that playing field, you have to look at all options.
Mr. Cotter?
I think the options are, it's very difficult to figure out what the options are for compelling China or any other nation to do what we want them to do with regard to intellectual property. I mean, most of that, I think, is going to have to be carried on through diplomacy and where possible through the WTO, but that is something that takes a lot of time and has its defects.
Doctor? I'm still looking for the cudgel here.
Yeah, I think that this is a challenge that also can involve stopping of importation of goods into other nations that are very clearly infringing, and as China seeks to access global markets, working with other nations to ensure that they're not accessing them with infringing products is an important step to consider.
I thank you for your comments. I know that you had additional things that you wanted to say. My time's expired. I yield back, but I thank you for your testimony.
It was good use of your time. Last and probably least, I'm going to wrap this up with a group of questions. First of all, I'd like to let you know that we had 4 pages of questions with follow-ups, and we didn't get to them all. So we'll be sending those to each of you and asking you to respond for the record. But there are a number of things that I think, in summary, that I'd like to touch on. First of all, although this hearing was very much put out as relative to China, I think it's fair, and I just an acknowledgement from all of you, that there's no question at all that although China is the most unfair player, there are deep concerns on this panel about Britain, Germany, and the EU in general, and their desire to lower their cost of SEP licensing. Is that fair to say?
If I may, I'm not sure that I would characterize it that way exactly. I mean, I don't think, honestly, that the courts in these countries necessarily have an agenda. They have very different perspectives, and so the UK courts, probably the most similar to our own, I think take a fairly balanced approach to these issues. The German courts, as I've mentioned, see injunctive relief as a matter of right, and so that tends to actually to give the SEP owners the advantage in those cases. That may change, as I mentioned in my written testimony. The European Commission may have other views on that, but remains to be seen.
Mr. Baker, that last point, if the whole world decided that SEP is great, but injunctive relief is essentially the default, how would that affect your ability to go to market?
It would effectively shut us down. The injunctions without first an analysis of whether or not an offer is FRAND, you can't determine if there's holdout. If you can't determine if there's holdout, why would you issue the injunction?
And the comment of diplomacy was used, and I appreciate that, serving on the Foreign Affairs Committee. But let me characterize a question for a moment. The most valuable diplomacy the United States has is probably immersed over in the Department of Commerce, not the Department of State. Is it fair to say that China's unfair activities that have been outlined today and the Britain and others' desire to have their courts make global decisions, and this idea that you can be banned hypothetically from seeking any relief elsewhere, all of those would be offset by U.S. diplomacy that simply said, you want access to our market, those rules are not acceptable. Is that a fair approach for the new administration to look at, that access to our market is so valuable that all of these activities that we see as unfair should be negotiated in light of access to our economy? Anyone disagree with that, Dr. Copan?
Yeah, let me comment. I think these are very, very important points that you're raising. And I do believe that the process that the UK courts have utilized to be very thoughtful in their analysis actually provide a really positive example for the United States with the United Kingdom as a close ally and partner. So I think rather than—
Wait a second, you're saying that a federal judge, otherwise known as somebody who thinks he's God, should simply say, we're going to make a decision for the whole world, even though the Constitution gives him no such power, and that would be good if we mirrored what Britain has done, at least on a few occasions?
I'm talking about the thoughtful approach of coming to
my
judgment
Article III judges are thoughtful. The question is more a matter of jurisdiction and sovereignty. So, you know, Mr. Baker, you've operated in all these areas. I know it's frustrating to have 200 countries, each of which asserts its own sovereignty, but is it fair to say that something between we'll make a decision for the world and then penalize you if you try to go to another country and seek remedy different there, and the idea that there's only one standard? That's really what global negotiations is about, is to try to cooperatively find it, not find it based on the decision of one judge, no matter how thoughtful.
Patents have regional boundaries. There's no doubt about that. A U.S. patent is valid in the U.S. and no place else. If there's going to be an exception to that rule relative to licensing, it either comes from the parties that say we agree to a global license coming out of a U.S. court, or it can be by the U.S. government, or through diplomacy, striking a negotiation where you find a broader than the regional application for a patent.
Now, there was one point brought up early on, and it was the fact that if I'm facing this, I love holding up my Chinese patent, it's small and worthless. But if I'm in a Chinese court, in 9 months, I'm going to be through my entire appeal process. Or is that not true, Mr. Cohen? If I'm in a Chinese court, but I'm an American patent holder, do I get done in 9 months, or is that a one-way street currently?
By law, it's a one-way street, which is to say that the mandatory timeframes for civil litigation, including the appeal in China, do not apply if it's a foreign-related case. What is a foreign-related case is an undefined term, but I think your appearance from the United States in a Chinese court would clearly be a foreign-related case. So cases will get drawn out, frequently because they're afraid of the diplomatic context, the political context, or perhaps for other reasons, but they do get drawn out for foreign.
So in closing, and there'll be a lot more questions that you've kindly said you'll answer for the record, if there was one thing in our dealing with China's access and China's implementation of their patents that you would want us to look at for next year, would be, I guess it's two things. One is find a way to match that 9 months as best we can in the U.S. to bring some level of parity, if at all possible. And then secondly, and I know the ITC was mentioned, we'll leave that where it was for now, but secondly, deal with the lack of reciprocity in that, you said it very well, Mr. Cohen, in the U.S., we do not look at the country of origin in an Article III court case or even at the PTO, and China does. And if that continues, then we'll never really we'll get justice between the two. It'd be sort of like the old days with the Russian judges at the Olympics. Anyone see that as not one of the key areas that we have to work to change? Any last closing remarks from any of the panelists before I send you off with your homework in writing? With that,
I would just add that my comments today were for small and medium-sized companies that represent 90% of the companies that are building out IoT. They're not large companies, much as you started with your technology in Viper, and then it grew into a larger entity. That's the type of customer that we have. If you license us and there is a SEP-FRAND relationship that can be struck, you're licensing 2,000 people or 2,000 companies at a time that will never pay royalties to a major patent holder if you don't license through us. If you want to go to the end product, the money won't be there in a U.S. court to sue them, and you're leaving that money on the table.
If I may add.
That's not fair.
Please.
And I really appreciate the opportunity to join with you today, the important focus on small and medium-sized enterprises as well, because these intellectual property enforceability issues are existential for these companies. The ability to continue to operate profitably on a global basis where we see an uneven playing field. The United States, as a free market economy, also has great benefits to lead the world by example, and to take an approach that is not regulatory forward, but enables the free market to really work, and then to work diplomatically and, to the point that was raised earlier, with economic force to ensure that, that China does pay attention.
Thank you. Yes.
Just briefly, I would just urge the subcommittee to be mindful that whatever measures Congress may see fit to pass to strengthen patent rights, they may see that as a desirable thing to do to respond to China or to increase incentives for innovators. But be mindful that some of those provisions, some of those actions could potentially backfire against other U.S. companies that need access to technology, that should not be excluded from the market, that should not be threatened by patent assertion entities wrongly. And I think there needs to be a balance.
Thank you. As we conclude, I'd like to yield to the ranking member if he has any end-of-year comments, particularly if they're related to the ranking member of the full committee who has appeared for the last time in that particular role here today.
Well, the gentleman is being quite judicious today, and I shall adopt that same stance towards ranking member Gerald Nadler, who has been ranking member or chair of this committee, I believe, for 15 years. He is stepping down from that position as of the 119th Congress. He'll become just a singular valued member of our committee, and Jamie Raskin will assume the ranking membership responsibilities. So at this time, on behalf of all of the members of the Judiciary Committee on this side of the aisle, I want to thank Jerry for his service, recognize the great service that he has rendered, wish him the best as we all move forward together, and I thank once again the chair of this subcommittee, my friend and partner, Darrell Issa, for the value that he has brought to the committee at large and his leadership of the subcommittee. And once again, happy holidays to everyone, and thank you all for your very great testimony today. Thank you.
Thank you.
I see a former member of Congress, Ed Perlmutter, who's in the house today. I want to shout him out, recognize him. And
with his Christmas tie on.
Yes, that's right. Yeah. And I see Jamie Simpson, who is here, former lead staffer on the committee, and also David Lockman, former committee staffer, is here as well. So good to see you all.
Thank you. I will note for the record that Ranking Member Nadler has expressed that he will continue to be on this subcommittee and has been both chairman and ranking member of this subcommittee additionally over the years. But this concludes today's hearing, and I want to thank all of our witnesses for what they have done for us here today and what they've agreed to do in the next 5 days to come. Without objection, all members will have 5 legislative days in which to submit additional written questions for the witnesses and additional materials for the record. And without objection, for the year, we stand adjourned.